for both sides to consider and evaluate and decide if both sides were going to accept it, and we were put on a clock of how much. He gave us time. You have to let us know by this date after we got the mediator's proposal. And that mediator's proposal, as everybody knows, the amount was $600 million, and it covered various claims that I'll get to next. We communicated with the class representatives, who were the people that filed the lawsuit, and the court said, hey, these are going to be your class representatives, and they are members of the communities in each of the different groups. Those were the people who had to go through discovery and sit through deposition and provide their documents to Norfolk Southern and go through that process. And because it was a class action, the class representatives do that in a representative capacity as well as their own individual capacity, so that not everybody goes through the litigation process itself. All of those class representatives gave us the approval before we entered into the agreement. Norfolk Southern had to get its internal approvals as well. And once both sides had all of their internal approvals, we let the court know, as we had to, and because Norfolk Southern is a publicly traded company, once there was a dollar amount, that's when it became public. And it wasn't until more recently, when we filed our preliminary approval papers, that the final details, some of the non-economic term details, were finally agreed on and submitted to Judge Pearson. That motion is already made, it's pending. We don't have a ruling yet. Judge Pearson has the obligation to look at the preliminary approval motion and critically review it and determine if the settlement as we've proposed it is fair, reasonable, and adequate for the members of the community, and also to make sure that it was negotiated at arm's length. And as part of that negotiation team, as I said, there were times it was acrimonious, it was done through the mediator, it was certainly at arm's length, and sometimes arguably more. So Judge Pearson is now undertaking her obligation to review the motion pending, and once we hear from the judge on whether she is going to preliminary approve the motion for the settlement, that's when the next phase would begin, and that would be the notice of the claims process. Now, Judge Pearson's obligation is singularly focused on, is this a fair, reasonable, adequate, negotiated settlement at arm's length? What she cannot do is change the amount or change the terms. She can just say, I'm rejecting it, go back to the drawing board, and go back to litigation, but she can't say that she doesn't like this term. We've also submitted to her the notice plan, and that she can change. So our notice plan is for everybody in the class to get direct mail notice of the settlement, as well as publication notice. There'll be news reports, there'll be social media reports, but everybody in the class should get, and the intention is will get, a mail notice to them with a claim form. And some of the notice has, legal terms, and Judge Pearson can change those. She can change the claim form if she doesn't like, or she thinks we're missing a question. She can come back to us and say, hey, add this question, or take this question out, things like that, but she can't change the terms of the settlement. So once we have the preliminary approval of the settlement, then the claims process and the notice process begins. Okay, so everybody, if you're in the 20-mile radius, should get a notice, should get a claim form. And then the claims process begins. There'll be deadlines in those notices that Judge Pearson will set, and some of those are when your claim forms are going to be due. If you decide you want to opt out of the class components, the deadline for doing so will be in those, and those deadlines are set. So if you decide after that deadline to opt out, you can't do that. It's got to be by the deadline. Okay? If you submit your claim form late, there's no guarantee you'll be included in receiving an award. So when you get those notices, it's important that you look at the deadlines and adhere to the deadlines and calendar the deadlines. Now, we will have more town halls. Those deadlines are going to start from preliminary approval, so to some degree, we don't know what they will be right now. You know, we proposed them, but Judge Pearson could change them, saying we don't think that's enough time. Make it longer, make it this. If all goes according to what we've asked Judge Pearson for, our hope and our goal is that if the settlement, if we get the preliminary approval shortly, we'll have a final approval hearing, which would be after the claim deadline, after all the claims are submitted and being reviewed, after the opt-out deadlines. And a final approval, if that can happen sometime in the early fall, we're hopeful that we can start to get payments out to the community members this year. Those deadlines are all dependent on the step before it. So those are aspirational, and we're hopeful that we can get there with the goal of getting money to the community members this year. The claims form, or the claims process. We are going to have a brick and mortar claims office here in town. The people who need help or want help with their claim form can go in. You'll be able to talk to the claims administrator, you'll be able to bring all your documents, you'll be able to ask questions, you'll get the answers to your questions. So that will be here on Rebecca Street, right out at Rebecca Place. So in the old Norfolk Southern Community Center, that's the space we're taking over. It will be manned or staffed only by the claims administrator, not Norfolk Southern. They are not part of the claim review process. All right, that's just the claims administrator who still needs to be appointed by the court as part of the preliminary approval motion. So we can't get that started yet. We can't do any of that until we get that green light from the court. All right, so let's turn to the actual terms of the settlement. Part of it is a class action, and part of it is a voluntary personal injury component. Okay, that is not a class action, and the law is clear. Certifying a personal injury class is not a very easy thing to do anymore, and virtually impossible. So that is not a class action. That is a voluntary separate component that people can elect to participate in if you're in the first 10 miles. Okay? The class component is out to 20 miles, and it's residential property, those kinds of losses. Okay, so it's a per household, but one of the components would be how many people are in the household. But the biggest thing is, it's not everybody's getting the same. Okay, so a person who's within a mile or 2 miles is not going to receive the same award under the claims process as someone in mile 18 or 19. So you can't just take the total amount and divide it by the number of people that live in this 20-mile radius and say, oh, I'm only getting blank, and everybody's going to get the same. I know I've seen that information out there.
It's in the settlement. It
It's
says
not.
0 to 2, approximately 70,000 miles.
Right,
70,000
but it doesn't say 0 to 20, everybody's getting the same.
No,
That's the point.
there's a breakdown.
There are breakdowns by miles, and there are different criteria that will be utilized, and proximity to the derailment site is going to be one of the primary factors utilized in evaluating claims. So the people in East Palestine will be getting a greater award, all things being equal, to the people that are in the second half of the 20 miles, and especially as you get farther out, the awards will go down. That's just the way we've set it up. We think that's the way it is most fair, and that's what we've asked Judge Pearson to approve. The same for businesses. Again, it's out to 20 miles, but the businesses that have been impacted the most, that are closer in, will be awarded in the claims process, all things being equal. They will be able to show a greater loss. Now, there are advantages to settlement in any litigation and disadvantages to all litigation. We cannot turn back time. We cannot go back and make this town the way it was prior to the derailment. We wish we could. I don't think any of us have ever had a client that says, well, if I could go back, I wouldn't. I would still stay where I am and get compensation. That's just not the way the legal system works. So as part of the settlement, we've taken all the information we've developed, the discovery part, the expert part, into account in evaluating the mediator's proposal. Some of the important components. This is all new money. So Norfolk Southern had the community center and they paid some people X dollars for this or put them up for a night or two in a hotel. They are not getting a credit for that against the $600, okay? So that's not an offset. If they've paid, let's just say $1,000 into the community, they don't get $1,000 back from the $600. That's not the way it works. But on an individualized basis, if you received $100 from Norfolk Southern, and let's say you're awarded as part of the claims process $1,000, that offset of $900 or $100 means you'll receive an award of $900. And that $100 offset will go back into the pot for the people in the 10 miles to be redistributed pro rata. Okay, why? So that people aren't getting paid twice for the same thing. But it doesn't go back to Norfolk Southern, it stays in the community and it gets redistributed to the people most impacted. So that in a supplemental distribution, you will get a percentage of that $100, but you won't get the whole $100, so that it's fair to everybody, especially to the people who didn't go to the community center and get money from Norfolk Southern the first time for whatever reason. I know we've asked people to write questions down so we can get through everything. If you've got your questions, we can keep doing that process so we can keep going. And we're going to get through all the questions at the end. So because it's a class action, the trespass, those kinds of claims, the non-personal injury, because it's a class action, everybody here has the right to not participate. Okay? You can opt out, you can stay silent, but because it's a class action, that's a different component than the voluntary personal injury component, which is a non-class action. Where if you want to participate, you have to affirmatively opt in or elect to participate by submitting a claim form for the personal injury components. As opposed to the class action where you have to opt out to take yourself out of the class. And then if you do that, you can continue with your litigation. You can continue to sue Norfolk Southern, but you will be held to the standards of anyone in litigation. Means your experts will have to pass the scientific rigor of what is known as a case called Gallagher before they get to testify. And the court is the gatekeeper of that scientific information so that the jury understands it. You will have to go through and establish all the elements of your causes of action. Norfolk Southern will get to all of its defenses and blame everybody else that it wants to blame. For your injuries, they will be able to get into alternative causes of your injuries, as anybody in any litigation would. So those are the components that if you decide to opt out and pursue your own litigation. The same for the personal injury side. If you elect to not participate and decide to sue Norfolk Southern for personal injuries later on your own, you will be held to all of the obligations of a litigating plaintiff, including the time frame within which you brought your claim, alternative causes, the amount of damages, hiring the experts. So those are the options that everybody has. The classes, as it was pointed out, the mileage from the derailment site will drive what we anticipate the awards to be. The opt-out deadline is going to be set in the notice. You'll have to opt out by then, and if you decide after that deadline you want to opt out, it's not possible. That's just the way class action law works, and so make sure you understand and trigger those deadlines so that you can evaluate what you want to do. We all think and are in favor of the settlement. We think it gets fair compensation to the community. It gets it now. It does not have, it's not through litigation, which, trust me, Norfolk Southern would take this up and down to the Sixth Circuit Court of Appeals, no matter what the outcome is. And we have some legal hurdles. We know it. We've evaluated them. We think it's a very strong case, but no case is without risk. And the value of getting compensation to the community now, instead of after multiple appeals and potentially a decade of litigation, has value. So, I mean, all three of us up here have litigations going on that are a decade or more old, and those clients are still waiting to get compensated. So we took all of that into account, communicated all of it with the claims, or excuse me, with the class representatives, and that's kind of how we got to where we are. So the next step is waiting for the court to grant our motion for preliminary approval or deny it and have to figure out where to change things or go back into litigation, but we're optimistic that the court will view the settlement as fair, reasonable, and allow us to go through the claims process. So I know I've been hogging the mic, but let you guys chime in on some stuff.
I think Jane Conroy from Simmons Hanley Conroy, I think two important things to recognize. One is that Judge Pearson in Youngstown, in the federal court where these cases are all filed, has her eyes on this, and she has since the derailment. And so she's reading these papers and she is evaluating them, and we will know, we hope, within the next week or so, whether or not she's going to grant preliminary approval. So that would be an important date for everyone to watch, because if she does grant it, then all of the dates that Seth talked about, including when you decide whether or not you want to be a part of this, will flow from that date, and we'll get all of that information out so that those dates are clear, and the types of information that will be necessary to fill out the eligibility forms if you decide that you want to be a part of the litigation and the settlement. The other important thing to recognize is this is a very individual decision from everyone here and everyone in the community, and there are different factors, and everyone has experienced this derailment and the fire in a different way, and that is, it's a little bit difficult in the settlement papers to appreciate how those different factors can weigh for you, or maybe even a little bit against you, and what the settlement amounts might look like. But this is very individual, and we have seen, reports of, well, you just divide the 600 million and that's what people receive. That's not what this is. In fact, it's so very different, because these are individualized amounts based on what each household has gone through. So keep that in mind as we continue to work with the court and refine the papers, and as we set up the claims facility, and we have the ability to talk through what it would look like to become a part of this class action settlement.
Excuse me, I would like to make just one thing clear. You keep on talking about the 600 million. Well, after the lawyers take their part, we talk about that amount that'll be split between everybody else. Because it's not the 600 million that we're all going to get. It's what we get after the lawyers have taken their part of it.
180 million.
Yeah.
You are exactly right. The lawyers do get paid, and the court decides what the lawyers get paid, not us. So you do have a protection there.
So if it was a 40% in your contract, that's not, you're gonna do pro bono with that and just go with what the lawyer or what the judge says? Cause that would help the community a lot.
Well,
$160
the pro bono is a little tough, folks. You know, we have paid for the experts and done things like that, so we're not talking pro bono, but I wish we could. But yes, the court controls this.
Oh, so a lot of us
But I
still
can't tell you
thought-
what the court is, this is what I'm saying, it's early days. We need to pay attention to how the court is reacting to this, what she's seeing. That's why we don't have all the answers yet.
So it won't be like whatever your contract said plus what the judge says. It'll be what the judge says.
She's asked, it won't be what the contract is. I don't know, sitting here, whether Judge Pearson will say, all of the contracts are in effect. We don't know the answer to that.
I think on that point, though, we can say that historically, it is, when there is a class settlement, there's not also an individual fee, or vice versa, because there are multiple components to it. So historically, in other cases, the judges would step in and say that wouldn't be fair to charge one client with an attorney twice, then the class member that did it only is charged once. So there will be something, we just don't know what Judge Pearson is going to do, but we anticipate if the past is predictor of the present.
And we don't like to guess what federal judges think.
So,
They don't like it if we guess.
so they're basically saying if you guys are gonna get 180 million, I'm just saying we've seen that out there. Okay, so you guys would split the 180 million between all you guys.
If they gave us 180 million.
Well, no, I'm just saying,
Yeah, I mean,
that's been out there.
Yeah, no, and I get it, and I appreciate that. I think that one of the things that, the reason we're here today, and the reason we'll be back multiple times is because there's a lot of information. We're at the point, there is going to be a fee at some point. We're gonna ask for a fee, there's no doubt about that. What that fee is or what the judge allows, we don't know. We haven't even got to the stage because we're at what's called, as Seth was talking about, the preliminary approval. So the judge hasn't even told us if she's gonna say grace over the settlement. And so until we get to that stage, until she says yes and we move on to notice, we don't even worry about that. But we're going to petition for a fee, of course, and that is coming. I don't think it's 180 million, I don't know what it would be, but I don't know. But yes, that would go to. Oh, sure, that's a great point. There's a team of how many attorneys? I mean, probably close to over 20 law firms, probably, over 100 attorneys that have worked on this case. Whatever the fee is split amongst all of them. It doesn't go to the three of us, it doesn't go to one person. Every attorney bills by the hour. They put in hours. You want to say something?
Yeah, and like has been said, there has to be an application to the court for a fee, and the court will rule on what the fee is and who gets it. So that's the way class actions work. In Ohio and the Sixth Circuit, it's usually a percentage.
That's part of the fairness
And,
hearing.
yeah, and that's part of the final fairness hearing.
That's the ones in September?
Hopefully in September. And that's when that will be addressed, and before then is when we have to ask the court and justify the work that's been done. But in Ohio, and the federal appeals court that Ohio sits within, is typically a percentage. And in our preliminary approval, the percentage is usually 30 to 35%. We've not advised the court that that's what we're gonna ask for. I think in our preliminary approval papers, we advised we can ask something lower than that. I don't have it in front of me. But it's going to be based on a percentage of the recovery, the same way most individual contracts are, but it's not going to be at that level. So right now, we don't know what the court will do on fees. We don't have a crystal ball, so we can't even pretend to foresee what the court will do. But because it is settling in part as a class action, the court, part of her job, part of her obligation, is to evaluate and determine what fee is appropriate.
How many lawyers are divvying this up?
A lot of lawyers worked on the case, as we said, it's more than 20 or 25 firms and more than,
Probably more than 100.
yeah, So, again, we haven't gotten to that point.
Comes out of the 600, or is that taken, that is something taken separate, or your fee is
So-
600 minus whatever percent they discover?
So the 600 encompasses everything, the cost of the notice, the cost of the claims administration, the fee, it covers everything. Norfolk Southern is paying $600 million to resolve the cases, okay? From that is where all the money will come from. And what are the claims that are being covered? So separately, you've got the personal injury voluntary program. And in the class case,
Not to interrupt, but if you don't take the personal injury, and you say, I'm gonna take my chances, see what develops in the future, what is the statute for the time limitation to do that? To file a case against Norfolk Southern independently of taking this?
well, in Ohio, it's 2 years from the time you knew or should have known you were injured. Now, latent injuries are treated a little differently, but again, so depending on what the injury is, so for example, people who had eye irritation or even now some breathing problems, it would be 2 years from the time you knew of your injury.
So less than 1 year from now?
Yes, depending on what your injury is.
What about the ones that the doctors won't acknowledge, like memory problems and vision problems and neurological issues?
They're still remediating the cracks.
Well,
We're
but
still
it's-
exposed.
you still have Ohio law, or depending on where you live, I guess arguably Pennsylvania law.
Repeat it, I don't think.
So the question related to, what about injuries your doctors won't recognize as being related to the derailment and the aftermath? Well, again, if you're going to bring a personal injury claim in Ohio or Pennsylvania, it's 2 years from when you knew or should have known about what caused your injury. So, again, it depends on what the injury is, and there's a different rule for latent injuries. Okay, but it's still a component of the time that if you don't bring your claim within a certain period of time, you will be fined. For injuries that your doctors don't ascribe,
Well, there was a Zoom meeting early on telling them not to test for chemicals and not to acknowledge any symptoms, and that has carried on.
well, unfortunately, we don't, know what this